This program was made possible with the generous support of the Magnolia of Millbrae. The Magnolia of Millbrae is a senior living community that provides a variety of services and amenities to its residents. For more information, call 650-697-7000 or visit their website at www.themagnolia.com. MCTV thanks them for their support.
Welcome to Wellness Update. My name is Sherry Plambeck. I'm the Director of Sales and Marketing at the Magnolia of Millbrae. We are located in Millbrae, and we're a senior retirement community, and we offer independent living and assisted living. Today our topic is estate planning, and today we're going to be discussing the issue of death planning. Our guest today is Stephen Wohl. He is an attorney, 35 years of experience in San Mateo County, working with individuals and families. It's our pleasure to have you here today, Steve. Welcome.
Thank you, Sherry. It's a pleasure to be with you again today.
So, Steve, what options do we have for providing an orderly succession of assets after death? How does this work?
With estate planning for the death planning part of it, last time we discussed incapacity, but today we're going to focus on the death planning. Families and individuals have an opportunity to create written documents that direct who will handle that person or family's affairs after death and who will receive the assets that are left after someone's death. So there are different ways of providing an orderly succession of assets. Probably the most common way of creating a succession plan is through a document called a will. And a will.
But Steve, what happens if a person doesn't have any will written? There is nothing legal. So what happens to that individual in that case?
If an individual simply chooses to not make any written documents or just ignores the issue completely, then the state of California will determine how that individual's estate will be handled. Typically, if there are significant assets, the estate will have to go through the court system in a supervised proceeding called probate, and the court would then appoint an individual or an entity to be in charge of the affairs. That individual or entity may not be the person that the individual would pick had that individual taken the opportunity to make choices in writing. So it is up to the state of California to supervise and direct what happens. There is a set of laws called intestacy that dictates how an estate will be passed down at death. So there is a default plan, but again, that plan may not be what an individual would choose had he or she actually taken advantage of the opportunity to create an estate plan.
But say a person had property assets and maybe $500,000 in various other entities. That person's money then, if they did not have anything written, the state of California would decide where that money would go?
Yes, because there is, in the California statute, a list of relationships that get priority, and typically it just goes by next of kin. And so it's going to be whoever is closest in relationship, as determined by the state of California's laws, that would receive the property. So it may not be the people that the individual would choose to leave property to, and certainly if an individual would want a charity to benefit, charities are not blood relatives, so charities will never receive anything through an intestacy succession.
Does the state of California decide, say there was cash, say $500,000, does the state of California decide what that cash, will that go into coffers for the state of California?
The only way it really ends up, what they call it cheating to the estate, is if there are in fact no blood relatives to be found. And that's fairly unusual. Typically there's at least some blood relatives, but certainly if there's absolutely no one of blood relationship, it can end up enriching the state coffers.
So truly, we have an opportunity to speak up and have our voice heard. How do we go about doing that?
Well, again, there are different ways of doing it. Probably the most traditional and oldest way of a formal estate plan for death planning would be a will. And what a will is think of it as a letter to the court. It's a letter that says, "Dear Judge, when I pass away, I want this person or entity to be in charge of my affairs," called the executor. And then after all my bills are paid, this is who I want my beneficiaries to be to receive what's left of my estate.
Are there different types of wills?
There are different ways of creating wills. Having a lawyer draft a will for you is a very common way. An individual would go to an attorney, the attorney would draft a will, it would be signed in front of two witnesses, and then you would have a valid will. Some people choose to do their own will, and there's two ways of doing your own will. One way is to actually do it in your own handwriting, and that's called a holographic will. There are certain requirements under California law, namely it needs to be dated, it needs to be completely in the person's own handwriting, and it needs to be signed at the end of the document.
But no witnesses for that.
Witnesses are not required. A holographic will is certainly not a preferred way of doing it, but it is a lot better than nothing, because the court will take a holographic will and do its best to construe what the intent was of the person and try to make things happen the way it's expressed in that written document.
But if you have a holographic will, would that go to probate? Or because you have a handwritten document, it would not go to probate?
It has little to do with how the will was created, whether it goes to probate or not. It depends on what the individual's assets were. In California, if an individual owns real estate or other assets of $150,000 of value or more, generally those assets would be subject to a probate proceeding supervised by the court. So that's irrespective of whether you have a holographic will or an attorney drafted will. And I just want to interject, there's a third way of creating a will, and that's called a statutory will.
And explain that, please.
A statutory will is basically a pre-printed form where an individual can fill in the blanks and sign it in front of two witnesses. And that form is generally available on the California State Bar website or through other resources. And it is an easy way to create a very simple will.
Does that have to be notarized?
No, wills are never notarized. It's kind of a tie-in to the Old English system. Wills need to be witnessed if they're not done in someone's own hand. That is so witnesses can say that the person knew what he or she was doing and can attest to the fact that the individual was of sound mind. So wills are not notarized in the state of California. They just need to be witnessed, or if they're holographic wills, they can be just written entirely in the person's hand.
So if we take the example of a male, say this male is 37 years of age, he has over $150,000 worth of assets. He dropped dead instantly. Then, if I'm correct, this is going to go through probate. Is that correct?
Yes. If that individual either did not have a will at all or just had a basic will, those assets would have to go through probate to reach the next of kin or the designated beneficiaries in a will. So for many people, that is not very inviting, because anytime you involve the court, it is time-consuming, expensive, and rather cumbersome. So for some families and individuals, and actually for many families and individuals, they don't want their families to go through the expense or inconvenience of a probate. Now, probates do have some benefit because they are court-supervised proceedings, so there's less likelihood of something going sideways. If there's a judge supervising the affairs of the estate, it keeps it on the straight and narrow. But many families say, well, we don't need that expensive protection of a court. We are confident that our families can take care of things without the necessity of court supervision. And that's where families and individuals will ask me, what other options do we have?
And what other options are there out there?
One option is to name one or more people as joint owners of assets. For example, if I own a home and let's say I wanted my brother to receive it at my death, I could add my brother to the deed, but that is not a preferred way of handling assets passing at death, because if I add my brother to the title, that means if he gets sued and has a judgment, my house is suddenly very vulnerable to his judgment. Or if I decide I want to sell the house, I would need his signature. So adding a joint owner is not typically what people decide to do, because there can be liability and jeopardy, and you kind of lose control.
Can you have say, we'll use you as the example, if you have a spouse, you can have that spouse on there as a joint owner and then add your brother as well?
You can. That would be pretty unusual to do that. That wouldn't be a really good way of providing for succession, but certainly you can create joint ownership of assets with right of survivorship, and that will avoid probate. But again, there are some real downsides to doing it that way. And then, of course, if there's a problem where everybody passes away, either together or there's deaths and the title doesn't get updated, it can end up in probate anyway. So generally, joint ownership of property outside of spouses is really not a favored way of doing things. And that's why people consider other options. And probably the most viable option is to create what's called a living trust.
And explain exactly what a living trust is and how that really works.
What a living trust is an entity that's created by either an individual or by a couple during their lives that remains under control of the individuals or couple during their lifetimes. But once they pass away, the assets in the trust can pass down to the named beneficiaries without having to go through court or probate. So it's a very nice and convenient vehicle for delivering assets after death to your family or your charities or whoever you want to leave your assets to without having to go through the court system. So think of it as a vehicle that allows for the delivery of assets post-death without compromising your ability during your lifetime to use your assets just like you do before you had a trust. So it's just a very convenient and commonly used vehicle for delivery of assets post-death.
And are there other types of trusts besides?
Generally, families create revocable trusts, which means they can amend them, cancel them, and change them. In some situations, trusts that are called irrevocable trusts can be utilized. An irrevocable trust is a trust that can't be changed once it's created. The discussion of that topic is really beyond the scope of a fundamental discussion of death planning. But in some situations, irrevocable trusts can be a valuable supplemental tool in an estate plan. But most families who come to see me are looking to create a revocable living trust. They want to keep control of their assets during their lifetimes. And then once they pass away, they want their assets to be delivered to their loved ones or to their charities as conveniently and as economically as possible.
Is that something that should be updated every year?
It may need to be updated depending if life changes occur or if your preferences change. The beauty of a living trust is that it's not a final document until you pass away. Revocable living trust can be updated, revised, canceled up through the time of your death. So it's a work in progress, and I do recommend to my clients that they review their estate planning documents, including their trusts or wills, once a year if possible. I say that hoping they'll look at it at least every couple of years, but if they'll look at it every year, I think it's great. And what I recommend to my clients is to put copies of their estate planning documents with their tax documents, because you know they're going to look at their tax documents once a year.
Well, they probably should,
They
yes.
should. Hopefully they're filing their tax returns in a timely way. And if you put your tax papers with your copies of your estate planning, that may trigger, I'll take 10 or 15 minutes to look at my estate plan just to make sure it's still up to date. Because I've had clients come to see me who haven't looked at their estate planning documents for many years, and they've forgotten who they picked to be trustees or executors or guardians if they have minor children.
Well, now what happens with those trustees? I think it's very difficult because you can think you know somebody so well, whether it be a family member or a personal friend. I would think that people have to be very, very astute in picking trustees.
You have to be very selective. My standards are people are of great integrity and who have a track record of some business sense and of honesty. And also individuals that you really feel will carry forward what you want in a way that's faithful to your preferences. Now, I've had clients who really don't have anybody that they feel comfortable giving that responsibility to, and that's where they may look into things such as trust companies or banks or professional fiduciaries. There are people who do this type of work for a living, and they are held to a very high standard. And so not everybody is blessed to have family or friends that they feel they can be confident to give these responsibilities to.
Or to trust, because sometimes things can go astray.
That is true, and who you pick now, 5 years from now, may no longer be the right choices because their lives may have gone into a different direction, or your relationship with that person may have changed.
Now, those trustees or trustee that is listed on the document, do they gain a fee by being a trustee or
Generally,
trustees
trustees are entitled to be compensated. It does depend how the trust document is worded. Typically, the type of trust document I draft either provides for a certain percentage or reasonable compensation. Now, some trustees may choose not to be compensated. If it's family, they may say, I really don't want to take money away from the children. But trustees do work and they are entitled to be compensated. So the answer is yes, they are entitled to be compensated, just as if an executor in a probate also receives compensation.
So what happens, you so oftentimes hear people leave their estate to XYZ people in their living trust, etc., and maybe there are 3 or 4 children, adult children involved in this, and one particular adult child doesn't agree with the way this living trust is written. Can you put a clause in there where if that individual does not agree, then they only get $1 of the estate? Or
well, it's not so much that it says $1, but all estate planning documents that I draft for death planning have what's called disinheritance and no contest provisions that really address those issues. Unless someone who's challenging the integrity of the document prevails, if they fail in their efforts, if they were to receive any benefit under the terms of the will or trust, they forfeit that. So that's a very powerful disincentive. For example, if a child's disgruntled with what share the parent has provided him or her,
and I think that does happen in some
it
families.
does happen, and if they challenge the integrity of the document, and if they lose, they will lose what they were given. So it's really, you're rolling the dice. So you may not be happy with the percentage you're getting or the number you're getting, but if you challenge and you fail to win your case, the way the documents I draft, and most practitioners would draft them in the same way to provide a disincentive for challenging, that person risks what is in there for them.
So do they have to go to court over
Generally,
that then?
to challenge a will or a trust, they would have to challenge it through the court system. It's a very expensive proposition. And there are cases, but generally where they can win, but generally if the estate planning documents are drafted by an experienced family law practitioner who is diligent and ensures and documents the file appropriately as to the competence of the client, those challenges are very hard to win. But they do occur.
If a person has a will, do they need a trust as well?
It's more if they have a trust, do they need a will as well? It's kind of reverse.
So is the trust the first thing that a family would put together, or is it a will?
Well, it's concurrent. It's all part of an estate planning package, so to speak, to use a kind of a different type of word, but it's all part of the string of documents that need to be prepared. When you create a trust document, that is the primary document that provides for how your assets are going to pass at your death. But you still need to have a will, but it's a special kind of will. It's called a pour-over will. Think of it as a safety net or an insurance policy. That type of will references the trust. So if you've left something out of the trust, because when you create a living trust, you have to fund the trust. You have to put the title to your major assets, such as your home, your second home, your bank accounts, your investment accounts, into your name as trustee of the trust. But if you have failed to do that, or if you've opened a new account and just forgot to put it in the name of the trust, the will directs that it be added to the trust after your death. So it's a safety net. So you need to have that will just in case you've left something out, so everything can be administered as one entity. Or else you're going to have things that are not in the trust going one direction and things in the trust going a different direction. And generally people want everything to be administered uniformly. So you still need to have a will. And another reason that even if you have a trust that you would want to do a will potentially is if you have minor children, you may elect to use that will to nominate your guardians of who would take care of your children physically and who would manage any money or property that child may have.
So that would be done under the program of the will.
It can be done through the will. It can also be done as a standalone document, a nomination of guardians. It can be done either way. But the key thing is, if you do a trust, you do need to have that special kind of will called a pour-over will. But in a perfect world, none of your assets will be floating out there in your name individually, so the will really will do nothing. But we don't live in a perfect world. And I've actually had to handle probates of individuals who had a trust, but who had failed to put everything in the trust, or had opened a new account after the trust was created and did not put in the name of the trust. And so we've still had to do a probate for those assets that were outside of the trust.
Now, say to me that they have a living trust and documents such as healthcare directives are in that living trust. Is that the way living trusts are written? Or I know we talked about in our previous show that we did with you about incapacity, but do some people have in the living trust that document as well? Or is there just a paragraph that's in there?
Generally, that would not be the appropriate way to do that type of planning.
So some people might actually think they have advanced directives in their living trust, but in reality they might not.
They may be looking at language that talks about who is trustee if he or she becomes incapacitated. They may think that somehow that's telling that person can handle that individual's health care. That's not.
But it is separate totally.
It's a separate document. So the Advanced Healthcare Directive, which we discussed last time, is a standalone, completely separate document from a living trust. So you can create a living trust and choose not to create an Advanced Healthcare Directive. You can create an Advanced Healthcare Directive and choose not to do a living trust or do a will. You're covering some parts of the estate planning when you do that, but then you're leaving a hole in your estate plan, because if you know if you're going to become incapacitated first or die first, then you have a much better crystal ball than I have. So it's best to cover both sides of the estate planning. And typically my clients come to me and we end up creating the full estate plan, which covers the incapacity planning and the death planning. So
Tell me a little bit about how you fund the trust. How does that work exactly?
That's a very good question, because when my clients sign their trust document, sometimes they believe that they're done. But that really is just step one. Step one is creating the trust. But in order for the trust to be able to be effective, you have to fund the trust, which means you need to transfer your major assets into your name as trustee of the trust. For example, your home. If you have real property and you want that real property to be governed by the trust, the title needs to be changed from your name individually to your name as trustee of your trust. Or if it's a married couple, it would be spouses individually to spouses as trustees of the living trust. So you have to physically transfer title. Typically, when I work with my clients, I prepare the transfer documents for any property located in California. But if they have property outside the state of California, we can also include that in the trust. But typically we have to reach out to professionals in the other states who are able to prepare the appropriate documents. But things like bank accounts or brokerage accounts, those have to physically be transferred into the trust. So if you have an account at XYZ Bank that you want to put in the trust, you would need to go to that bank and inform the bank that you've created the trust and instruct the bank to change the title. So you have to fund the trust. That's very important. That's part two. Once you create the trust, part two is funding the trust so that the trust has the ability to govern those assets.
So say somebody is the trustee on an estate. What happens with the property taxes, say on property?
Typically, if it's a living trust created for the benefit of the person who owned the property in the first place, it's absolutely neutral. That's not a transfer that triggers a reassessment or triggers any documentary transfer tax, because it's not a sale. It's not considered to be a transfer under Prop 13 laws, so there would be no reassessment if the documents are all prepared properly. So because if people had reassessments due to creating living trusts, I think you'd have a lot less trusts created, because nobody wants to pay more property taxes than they have to.
No, I don't think they do, especially in the state of California, although we're not the highest, but we're far from the lowest.
I like to say property taxes are the gift that keeps giving. It's not just a one-shot thing, it's every year. So
it does keep giving. That's a very good way to phrase it.
Yes.
What happens if a person has, say, a 401k account, IRAs, What happens with those funds, annuities, life insurance policies, if they have a beneficiary on them? Do those documents need to go in the living trust as well?
That's also an excellent question, because the ownership of those assets typically remain in the name of the individual. So if you have a life insurance policy or an annuity, or you hold a 401k or an IRA in your name, creating a living trust does not mean that you change the title of the ownership. That stays the same as it was before you created the trust. However, those type of assets have what's called a designation of beneficiary feature. It allows you to name who receives whatever's left of that asset or that asset itself at death. And so you can name a beneficiary. Now, if you want the trust to be the beneficiary, you can name the trust to be the beneficiary of those assets. Or you can simply name individuals or charities as the direct beneficiary. So when you set up a living trust, you don't have to change the title of those assets, but you may need to redo the designation of beneficiaries depending on what your plan is.
So again, they could be funded into the living trust as well.
You could have those assets flow into the trust after death, and that's because of the designation of beneficiary feature. A house doesn't have that feature. I can't designate that my house go to my brother at my death. Title to real estate doesn't have that ability. You can't do that. But life insurance does. I could name my brother as the beneficiary of my policy, even if I didn't have a trust. But if I want my brother to receive that house without going through probate, I would have to create a trust and then have my brother named as the beneficiary of the trust, so that when I pass away, he gets entitlement to the title after I'm gone.
But say a person did not have a will, they didn't have a living trust, but they had 401k, they had life insurance, they had an annuity, and they had a beneficiary on those. So the beneficiary that was on each of those documents would then still be able to garner those funds, etc. But then the rest of that money would have to go to a probate court. Am I correct there?
Yes. So anything that has a beneficiary designation, such as the things you mentioned, life insurance, 401ks, as long as there's a alive and well beneficiary to claim it, irrespective of whether they have a will or a trust, those beneficiaries will be able to receive that money. But if the same person has a house or has $200,000 in an investment account, no will, no trust, it's going to go through probate. And if there's a will, it'll go the way the will dictates. If the person dies intestate, it's going to go the way the state of California dictates.
So it is crucial to have a beneficiary listed on those documents, at least a 401k, an IRA, etc.
Yes, that's
better than nothing.
Well, you should always do that. I mean, and entities will ask you when you set up the account, but sometimes people are not good in updating that. I've had people bring these documents and the beneficiaries they've named are now deceased, or there may be former spouses and they've forgotten to change it. There's a whole variety of way that these problems can arise. So it's part of your estate plan review is to also review your beneficiary designations on all those type of instruments, just to make sure that you know who's named as the beneficiary, and make sure there's your preference, and also make sure the person's still around.
Well, you know, I think we've learned a great deal today. I really appreciate you taking the time to spend with us both on incapacity planning and death planning, because I think those are two things that are so important. And most of us in our busy lives, we're not thinking of doing all of these documents. And I think at any age, it's really crucial for people to know that they need to have these documents in place. They do have the opportunity. They can make the choice if they wish. Otherwise, the state will be making the choice, and we don't ever want that, because you have that right, and we need to respect that right.
And you need to take advantage of that right. And the reality is no one's favorite subjects are death and incapacity, but
they're important.
And it's just, if you just handle it as being part of taking care of business.
They're a part of, you know, it's like doing your taxes every year, and I think that's a very good point, is we should have those documents, or at least copies of those documents, in a place where we also have our taxes, because somehow or other we're always able to find those taxes by April the 15th, or we hope we can. I want to thank you so much for spending the time and coming and really explaining both of these issues, because they are important. Meanwhile, thank you all for visiting with us today. Live each day. Life is so very, very precious.
Thank you, Sherry.
This program was made possible with the generous support of the Magnolia of Millbrae. The Magnolia of Millbrae is a senior living community that provides a variety of services and amenities to its residents. For more information, call 650-697-7000 or visit their website at www.themagnolia.com. MCTV thanks them for their support.